So good afternoon. Good afternoon. Welcome back to all of you to this joint webinar between Protect, Vulner, and Asile projects. It's been a fascinating session. A lot of research being exchanged and super interesting conversations and debates. Now, the next step that we are taking in panel 3 is kind of looking a little bit back. So bringing some historical background of temporary protection in Europe, and also looking forward in the sense that, or the extent to which the activation of the Temporary Protection Directive invites us to rethink the guiding principles and some of the parameters that characterize the now moment, the existing EU asylum policies. Now, for this purpose, we have four distinguished speakers, and who will take us through a number of very interesting points and presentations. I will start by introducing the first speaker, Professor Frank Kaestecker. He's working at the Faculty of Economics and Business Administration at the University of Ghent, and he will start indeed by highlighting some historical perspectives on temporary protection. So Frank, you have the floor.
Thank you very much. Good afternoon, and thank you for the invitation. As a historian, I look rather to the past and the future in order to better understand the past, the present and the future. So I think it's useful to present an overview of the history of temporary protection as a tool in migration management. It can have different purposes and serve different agendas. So I will speak about Western Europe, not about Europe, because most of my examples are in the time when there was the Cold War or when it just was finished, or before that even. I first want to go way back in time, back to the 1930s, when we have the first experiments in modern refugee policy. Then it started all, and temporary protection was tried out for the first time. The start of refugee policy, as we know it nowadays, is to be located in the 1930s during the Depression. All Western European states at that time started a protectionist immigration policy. Then it got shaped, and they wanted to keep immigrants out. They didn't need immigrants anymore. There was large unemployment rates. So they were constructing a protectionist immigration policy. And immediately at that time too, there was a challenge of the arrival about several thousand of Jews, 110,000 of Jews coming from Nazi Germany. So Hitler took power in 1933, and they were determined to kick out the Jews, about 500,000 Germans, out of the German. They wanted to kick them out of the German nation and territory. In most West European countries, they were given only temporary protection. They had not the right to work, not the right to settle. This made them totally dependent on private aid, on financial support by refugee aid organizations. Temporary protection meant only tolerating them and pressurizing them to move on, mostly overseas, as it was clear that returning home was excluded for them. But integration in the first country of asylum, seeing the large number they thought at that time, and seeing the times, the economic depression, integration was excluded, so that they had to move on. So this was part of this newly created international refugee regime, because one realized too that any protective measure needed to be taken by more countries. Otherwise, the one country who pursued a rather humanitarian policy risked becoming a magnet. At that time, the idea of first country of asylum was found as a useful principle. And also the principle of non-refoulement was already set as a basic principle of refugee policy. So refugee policy had to provide for admission, mostly temporary, for sensitive cases. So those people you cannot return, but you can stop all other people at the border or even deport them from your country. for sensitive cases, for refugees, that would be more contested. So making refugee policy meant to make the protectionist immigration policy more effective. It was like a sluice gate in the dam or a side door while the main gate was closed. In this historical case, temporary protection was a humanitarian policy to enable refugees to organize their final migration to the resettlement country. The second experience in the history of temporary protection is to be located in the early 1990s with the war refugees from Yugoslavia, which exploded. Let me recall a bit the context of that era. In the 1980s, the West European countries were slowly reorganizing their asylum system, because due to a redefinition and strengthening also of the protectionist immigration policy, and at the same time an accelerated globalization, the asylum institutions, which were small institutions, not very developed, they were confronted with a higher influx of asylum seekers from the global south. The post-industrial transition had brought a selective closing of their borders along, and asylum became used not only for protection, as a protection mechanism, but also as an immigration channel. Then the collapse of the communist bloc in 1989-1990 meant that the environment in which this reorganization of the asylum system was taking place was changing profoundly. Policy makers had to take into account a new migration pressure, not only from the south, but especially from the east. The end of the Cold War meant that people from the Eastern Bloc could leave their countries, and there was a serious fear among the governments across Western Europe that East Europeans and even Russians would arrive in large numbers. The only country, it seems to me, which had made this reorganization final was France. It's the only country which didn't really have any more in 92, at the end of 91, 92, when refugees come from Yugoslavia, who didn't have a huge backlog in asylum claims. So at the end of 91, when the war in Yugoslavia started, you had people looking for protection in Western European states, but they were confronted with states which were erecting barriers to asylum seekers. They wanted to stop people from applying for asylum. And UNHCR realized this. And UNHCR advocated a quick solution for Bosnian refugees. And they believed that European governments would be more willing to admit large numbers of war refugees when this happened outside of the regular asylum procedure. So that's why they proposed temporary protection. It was conceived as a way to grant Bosnian protection without making them apply for asylum. It would save the already overwhelmed European states' asylum systems from a huge influx of refugees. UNHCR insisted that the status of temporary protection had to be attractive enough to make this happen, to have not new asylum applicants from Yugoslavia. War refugee would not apply for regular asylum, UNHCR said, if they would have an attractive temporary protection. So that means, concretely for UNHCR, you should give them a resident permit for 1 year, so very similar to what we have now with the Ukrainians, and you should also grant them the right to work. All West European states, even those who had very few people coming from Yugoslavia, they all introduced this, they all accepted this program. But in fact, only Italy and Switzerland accepted fully the proposal of UNHCR to make it an attractive program. In Italy, it took, however, 9 months until September 92 before the Italian temporary protection scheme got its final form in the sense, as UNHCR wanted, a 1-year residence permit and the right to work. Originally, Italy had only given permits for 2 months. And also the Council of Ministers had decided we should put a ceiling on this intake of war refugees. We shouldn't be overwhelmed. We shouldn't take too many. How many was not very clear. But a bit later, in September 92, the Italian parliament decided to do away with this ceiling. and also not to grant 2 months, but a 1-year permit. So it was the Italian MPs, members of parliament, who abolished this possible maximum limit and made it more attractive. Elsewhere in Western Europe, Parliament hardly played a role. It was mostly the administration who did it, and their main focus was on limiting the rights of beneficiaries of temporary protection. Most countries only offered permits of 3 weeks, which were renewable, and no right to work, very few rights to those people. So for a very short time, they provided protection, but renewable. The authorities accepted to be that the Yugoslavian crisis would be short-lived and that they would be quickly able to make war refugees return home. So they returned them on short notice. Definitely, they didn't want them to stay. Germany, Austria, and Italy are closest, were the frontline states. They introduced temporary protection already in 1991. The other countries who also introduced temporary protection took much more time. Belgium and France did it only in August 92. Denmark was the last in line when, I think, in November 92, they provided a clear temporary protection status to Bosnian refugees. This late reaction, because that means 6, 8, 9 months after the war really started, after the refugees from Bosnia arrived, means that many of the war refugees remained in the country as asylum seekers and mostly as rejected asylum seekers. So they were in a legal limbo for a certain time, for a long time, for several months, half a year. And the reason why this took so long in all these countries is that the authorities were not eager to sign a blanco check with an unknown number of people who would claim this protection. So similar to the ceiling of the Italians, this was the cause for their belated reaction. And mostly they introduced temporary protection when they imposed at the same time a visa obligation on Bosnian nationals. The authorities were afraid that temporary protection would function as a pull factor. In Denmark and in Austria, they went even further. As they said, it's a further illustration of this importance of migration control, because as well the Danish as the Austrian authorities denied to their temporary protection scheme all people who immigrated irregularly after a cutoff date. UNHCR insisted also, when they made this proposal for temporary protection, that it shouldn't be used as a means to preclude refugees when they would fall under the scope of the 1951 Convention to apply for refugee status. Most countries did not heed this. The most notorious example is Austria. They had a recognition rate for war refugees of 5%, so they all rejected them. On top of that, if you were rejected as an asylum seeker from Bosnia, then you were dropped from the care and maintenance scheme for asylum seeker, which is normal, but they were also denied access to the special assistance program for refugees within this framework of temporary protection introduced by the Austrian authorities. This caused a large number of Bosnian asylum seekers, so people who had applied asylum, that they felt obliged to withdraw their asylum application. The chances were slim anyway to be recognized. And then you would have, as a punishment, you would not qualify for any other support within the temporary protection scheme. The whole UNHCR proposal of temporary protection backfired too. Everybody, all countries adopted it, but at the same time, they remained decided to stop Bosnian refugees to come to their country. They should stay in Yugoslavia and the other republics, or in so-called safe areas. Also, proposals for burden sharing had little response. All Western European countries, except Italy, introduced visa requirement for Bosnian nationals, and visa to applicants for Bosnia were hardly granted. And so if you needed to look for protection, you had to enter the West European countries in an irregular manner. pushbacks were reported. Austria is again the worst example. It was the first country to do so. By May 4th, 1992, when the war was still in the middle of the war, the Austrian-Yugoslavian border was closed to refugees for Bosnia. The official legitimation was that it was necessary to stop its open door policy, as it had been misused by Serbia for the furtherance of its ethnic purification policy. So the fight against ethnic cleansing was closing your border, kind of a strange reasoning to legitimize closing of the border. The interesting thing is that Austria and Germany had at that time already temporary protection in their laws, in the legislation. Temporary protection seems to be a very unloved instrument for refugee protection, because neither Austria nor Germany used it. There was no political will to use it to protect the Bosnian refugees. Germany only used in 1999 when they decided to take about 20,000 Kosovo refugees to give them a chance to be protected temporarily in Germany. So only then this legislative possibility was being used. And this was within a framework of a well-organized intake of refugees, the humanitarian evacuation program. So for matters of immigration control, it was a well-prescribed number of people who would qualify for it. So the directive of 2001 came also because the Germans wanted to have more guarantees for burden sharing. And in contrast to what we see in the 90s, we see that it's not developed, it has a very different objective. It's not meant to weaken the protection system of the Convention of Geneva. It's rather making an antechamber for people to wait until it became necessary for them to stay longer and to apply for asylum eventually. So it's a different kind of protection which we see with the directive and how it's certainly how it's now implemented than originally was taking place in the 90s when the first program of temporary protection was being used. It's much more a proactive measure now than a preventive measure. It also offers more guarantees, at least the minimum requirements offers at least some guarantees which were not there in the early 1990s when Bosnian refugees looked for protection. I think I can close hereby. Very interesting to hear the future of this story too. But we should remember that temporary protection can have different agendas and different programs can be constructed on the base of that program. Thank you very much for your attention.
Thank you for your excellent presentation and for inviting us to remember these different phases that temporary protection has taken or adopted, in the years that you've explained more in a historical perspective, from this more preventive approach to a more proactive, as you've mentioned, dimension that we find in the directive nowadays. And it's interesting you mentioned another factor that was present in the morning sessions, this argument of pull factor being put forward by some actors. Thank you so much, Frank. Now, next presentation is by Professor Jens Vested Hansen. He is part of the Asylum Network and actually one of the most active members, a long-standing expert and academic on refugee protection. And Jens, we look forward to hearing your presentation.
Thank you very much, Sergio, and thank you also to Håkan and Luc for co-organizing this event. I think it was a fascinating idea to make this joint webinar on such relevant topics. I have been in this business long enough to be able also to recall events from the 1990s, and it was very fascinating to listen to your presentation, Frank. I think mine is going to be partly in parallel, and then I'll maybe draw some cautious lines for possible future development as well. If we look at temporary protection in Europe in the 1990s, I think it was significant that the arrangements gradually introduced, as you described, they were part of, or at least linked to, an international framework for responses to the crisis in the Balkans. There were UNHCR plans for a coordinated and comprehensive response to the humanitarian crisis in ex-Yugoslavia. I think I'm almost here quoting a document from UNHCR back in 1992. And these plans included or were coordinated also with wider international efforts to bring the civil war to an end. They were not particularly successful. It took more than 3 years, as we all know. But this made the framework for the protection response based on the expectation that the need for protection would be temporary. And this goes well in line with what Boldisha reported this morning, also about the situation in some of the neighboring countries in particular. So there was actually a focus on repatriation at the end of the conflict, which was then part of the reasoning behind the temporariness of protection arrangements. In hindsight, I think it is relevant to make have some reflections over what was the rationale of these temporary protection arrangements. If we first look at the overall rationale as indicated, for instance, by UNHCR positions, I think there was an idea that temporariness could also be seen as a part of the strategy to prevent ethnic cleansing, which was perhaps in itself a rather cynical approach. It could be the flip side, one could say, of the expectation of the temporary need of the nature of the protection need. But the very idea of making protection responses part of the prevention of cleansing is fundamentally, I would say, a kind of instrumentalization. And it was exactly what you, Frank, also just before described as also part of the border closures that they were also seen or attempted to be justified as a part of the strategy to not to help those conducting ethnic cleansing. But of course, we saw the high price to be paid for this strategy in the Srebrenica massacre in 1995. Another reflection after the end of temporary protection was whether temporary protection was in fact just a slow way of accepting permanent residence. Or on the other hand, it could also be seen as a vehicle for early or even premature repatriation. Here, I think the answers will vary a good deal across European states because, as we all know, and as it was reported before, the various European states had quite different approaches to the temporary protection schemes. I was working from 1995 and a few years onward with a comparative, or as part of a comparative study on the various temporary responses in the Nordic countries during the conflicts in ex-Yugoslavia. And here again, I think we saw, in line with the international framework, we saw some overall protective purposes of the arrangements. And this, I think, is to be seen in sharp contrast to the more recent tendencies in Denmark and other countries towards what in Denmark is referred to as a paradigm shift towards enhanced focus on cessation and withdrawal. I may come back to that if time allows. But I think the overall idea behind temporariness of protection was, again, as I stated, to respond to a European displacement crisis in line with international arrangements and in some coordination informally with European partners. But overall also with the purpose of enhancing asylum capacity. The idea was to grant protection on a collective or at least prima facie basis. That granting of protection was based mostly on criteria developed or recommended by the UNHCR. This took place by way of special protection arrangements outside the ordinary asylum system. And fourthly, this special protection arrangement then allowed for the suspension of individualized examination of asylum cases. If we look at the Nordic countries, there were some quite significant differences actually, because in Norway and Denmark, the temporary protection schemes were based precisely on suspension or freezing of individualized examinations, while that was different in Sweden. Similarly, we also saw in the Nordic countries some different models and standards of protection for those granted temporary protection. In Denmark and Norway, the temporary the permits, residence permits granted to the Bosnian refugees, as they were the vast majority of these coming within the scheme, their residence permits were explicitly temporary. That was somewhat different again in Sweden, and as far as I recall also in Finland, where they actually shifted to permanent permits after a rather short period. This must be seen as reflecting a Swedish tradition until recently at least, to give permanent residence to newly arrived refugees as very shortly upon recognition. The second difference was that the Nordic countries took different approaches to the issue of integration or integration prospects. In Denmark, the Bosnian refugees under temporary protection were initially sort of kept in a limbo. In fact, they were accommodated in special centers. They were not allowed to seek or take up employment, and there was no integration program covering their situation. So that was sort of truly reflecting the expectation of the temporary nature and the sort of prospective repatriation. That was different in Norway and Sweden, where they actually had a very different strategy. I think in Norway, most manifestly by way of the reasoning that integrating or offering at least integration possibilities with a framework for having an ordinary life would be the best way of enhancing the capacity of the displaced persons to repatriate, which is a very interesting and sympathetic approach, of course. As I mentioned, Denmark took a different approach, initially kept people in limbos and then gradually allowed them to take up some kind of activity, meaningful activities, finally even potentially paid or voluntary work, just as children were also gradually offered education in line with what is offered or was offered for Danish children in primary schooling age. So we saw some similarities and also some quite significant differences across the Nordic countries. After the Bosnian crisis, that is since 1995, at least Denmark and Norway offered the possibility to activate asylum applications or to lodge applications for those who hadn't done so yet. And in practice, the vast majority of those who had been under temporary protection were actually granted either convention refugee status or, in Denmark, mostly subsidiary protection status. If we now leave behind the 1990s and look at what happens after that, I think it is quite remarkable that there was a limited interest, as far as I can see and recall, for temporary protection solutions after the Balkan crisis. Of course, it re-emerged on the occasion of the Kosovo crisis in 1998 and 9. We even had another special legislation adopted in Denmark for that. And interestingly, for the Kosovars, there was a more explicit focus on repatriation, and I think that was not so successful altogether. There were quite many of them who were not willing to repatriate and who then resorted to humanitarian residence permits, which were actually in practice quite difficult for them to obtain. Apart from the state level, there was also little interest for temporary protection after the end of the Balkan crisis. UNHCR did little, as far as I recall. There was also a very short study conducted by the IGC, the Intergovernmental Consultations on Migration, Asylum and Refugees, and that was it, to my knowledge. Then, of course, we had an emerging EU harmonization already in the spring of 1996, that is less than 3 months after the Dayton Peace Agreement. The EU actually adopted a council decision that was in the Amsterdam era of intergovernmental harmonization. So there was a council decision adopted on an alert and emergency procedure for burden sharing with regard to the admission and residence of displaced persons on a temporary basis. That was the full title, clearly reflecting that the purpose here was probably more burden sharing or sharing of responsibilities and procedures to that effect than it was providing protection as such. I recall that quite a number of us were quite skeptical to this because it was a half-hearted solution. And then finally, the step was taken, as has been mentioned several times today, with the adoption in 2001 of Directive 2001/55. It's then interesting to see, as we have heard and seen others do. Meltem made an excellent account for this very early in March, if not late February, on the Odysseus blog. Why was the Temporary Protection Directive not activated during the 2015 plus asylum crisis? I'm not going further into that. That has been solidly accounted for and debated. But I think it's interesting to look at what happened as a result of the non-activation of the TPD. That was, I think, varying and quite different European responses to the influx of people who had been displaced by armed conflict or generalized violence in Afghanistan, Iraq, in particular, of course, in Syria. And that sort of resulted in unilateral arrangements with a kind of often temporary nature, I think, but without the international coordination or the harmonized EU standards underlying the arrangements. And in practice, I think that in a number of countries, this resulted in a kind of erosion of protection standards for people who were at best granted subsidiary, if not tertiary, protection status. So this was a kind of, if the responses to the Balkan crisis in the 90s was a kind of good example, and in particular, as the TPD as adopted in 2001 was a fortunate instrument, although, as it was stated this morning, a dormant beauty. We then saw the flip side or the consequences of the absence of coordination and harmonization in the responses to the influx from Syria in particular in 2005 and 15 and later on. And in some countries, this has, as part of the responses to the asylum crisis, we have even seen more radical initiatives towards eroding protection standards and de facto making protection temporary, not on the particular basis of expectations of early repatriation, but just simply as a way of making protection less attractive. So it has also been a part of the race towards the bottom, probably. This is in itself worthwhile discussing. I think it would be beyond our framework for today, and I'm also afraid that my time has soon ended. So I'll just say that a few words about prospects for the future development of the Common European Asylum System. I think there is a general sense of relief that the EU member states managed to respond as they did to the arrival of so many displaced persons from Ukraine. Together with Julia Kienast and Nicholas Tan, I published a blog on the Asyl Forum last week, where we are trying to discuss the extent to which the clearly differential treatment of Ukrainian refugees is to be seen as just legitimate differences of treatment or as discriminatory. I think the answer to this complex question is quite difficult and also has to be given with quite many nuances. But I think it's important to be aware that applying the Temporary Protection Directive is an advantage at the outset, but over time it will become a relative disadvantage because the protection standards, insofar as they are fixed in the directive, are lower, and many of them are quite vague, in fact. So therefore, I think if, God forbid it, but if the conflict in Ukraine gets protracted, then I think we will see situations where there will be a need to open for processing applications for refugee status or subsidiary protection status in line with the Qualification Directive. Simply because if people are likely to be within the Refugee Convention definition, then it will be unsustainable to keep them on lower standards for a longer period of time. And that problem will sort of become gradually more relevant, I think, as time goes by. And of course, it will then be interesting to see whether it is possible to assess the need for protection in accordance with the convention and the Qualification Directive. Whether it will be possible and what the outcome will be, that's in itself going to be terribly interesting if it should happen that badly, that the conflict will last so long. Another prospect for the future development that I would like to mention finally is also the reality of a strong agency of the displaced persons. They have what can be considered free movement. Daniel Tim discussed that in another interesting and excellent contribution to the Düsseldorf blog back in early March. And that's, of course, also an interesting difference in itself, because what is normally considered in pejorative terms as secondary movement, which is a beast we don't want in asylum policy, here we, as a consequence of the exemption for visa requirements for Ukrainians, in fact, accept not only free access to the territory, but also free movement around member states, which has even been reinforced by the decision not to apply Article 11 of the Temporary Protection Directive. This is what many advocates have been looking for, longing for even, as a contrast to the Dublin system. And it will, of course, be interesting to see how long this open borders, not only towards Ukraine, but also across member states, will be upheld. Interestingly, those under the TPD scheme can use the free movement rights, if we wish, as a kind of voting with their feet. They can simply use it as a strategy to move to countries that will offer better conditions in case they are in a member state which either doesn't comply with the TPD or at least uses the flexibility of the standards in the TPD to offer them insufficient conditions. Again, we will see that we can see that as an expression of agency of the displaced, but it will also be interesting to see for how long member states will accept this right to de facto free movement. Thank you for your attention.
Thank you, Jens, for your excellent presentation. Super interesting. Let's now move to Lilia Oprisk. She's associate professor at the University of Bergen. Lilia, we look forward to hearing your presentation.
Thank you very much, and I thank you so much for inviting me. I'm Ukrainian, and I'm very happy to be here and your thoughts on the protection of Ukrainians fleeing from war. I have to mention that my research field, it's not exactly the refugee law. So I thought what I'm going to talk about today is the status of internally displaced persons in Ukraine. So maybe give you a bit of an overview on that. Because of course, people are not only fleeing outside of Ukraine, but we had a lot of people who had to leave their homes since 2014, since the annexation of Crimea and the start of this hybrid war in Donbass. And in Ukrainian history, it was not the first time where we had some kind of a special temporary status. We had also the Chernobyl disaster. After that, there was some special status rights for those persons to help them because they had to leave their homes. But of course, 2014 was the first time that the law on that scale was adopted in Ukraine. And this law is called on ensuring the rights and freedoms of internally displaced persons. It was adopted in October, and then also followed the registry or database of the internally displaced persons since 2015. So this law aims to protect the rights of the persons who had to flee their homes and to make sure that they can effectively exercise their rights to education, to work, to social security, etc. And there have been also some strategies for reintegrating these displaced people, and as well as housing programs. There were some dates here which I mentioned for Crimea and Donetsk and Luhansk Oblast, or some regions within there, which were relevant for the provisions, for instance, where somebody has taken a loan and then the state would go in and help them with that. And there were major changes which took place in 2016 because in the law that was adopted in 2014, it was not clear if persons who were not Ukrainian citizens would be able to get this temporary protection status after 2016. The definition of internally displaced persons has been changed. And also before 2016, it was like a 6 months period, which you could extend. And now it doesn't have any expiration date, so it's until further that the status is given. Of course, it is still considered to be temporary. So in Article 1, Paragraph 1, the law defines the internally displaced person as citizen of Ukraine, foreigner, or a stateless person who is legally present on the territory of Ukraine and has the right to permanent residence, which is important, and who had to leave or abandon the place of residence as a result or in order to avoid the negative consequences of violence, human rights violations, and natural or man-made emergencies. So this status is individual. The persons have to apply to be recognized as an internally displaced person, and it gives access for protection of exercising the rights on this different fields, employment, pensions, etc. And it secures their participation in voting and other rights such as family unity, safe living conditions, etc. Of course, when the full-scale attack on Ukraine happened in February, the law had to be amended. So what was made was to make a reference to the regions of Ukraine, so-called oblasts. You can see them marked in yellow, because the geographical application would be extended, but also a reference to the list on where actually this military operation is taking place, but that I will come back to later. And also there was introduced an online registration, which makes it much easier for those who have to flee, so they can do it online in our application, which is called DIA, where you get a lot of, by now, a lot of government services, which you previously had to go to some local administration to get it done. And in the first 6 days, it was reported that over 200,000 people registered as this internally displaced persons in this time. And statistics, what we have now from the Ministry of Social Policy of Ukraine as of end of April, is that there are almost 3.5 million of internally displaced persons, and over 2 million have registered since February 24, and almost all of them fled for the first time. But the estimate is actually 7.7 million internally displaced persons in Ukraine. Many of them might have gone outside of the territory, so to the neighboring European states, or on the basis of visa-free regime to the other countries in Europe. And yeah, there is a movement statistics since February on the border crossing. I think it's from the 3rd of May that there are over 5.5 million people who crossed border from Ukraine, and then almost 1.5 who crossed into Ukraine. The question is how many actually returned, because we have also a large population who works in the European Union, and the countries who just basically came back. There's also a significant part who has returned to Ukraine since 21st of May. And there are some challenges now, because suddenly there are so many more internally displaced persons than we had before 21st of February. And one of the challenges is that the list of territories on which there are active active military operation. Of course, it's updated on a regular basis, and when the list came out, it does not include, for instance, Crimea, or it did not include these eastern parts of Ukraine, which were already under occupation since 2014 or years afterwards. But by now it seemed to be clarified from the ministry side that those people are still being considered eligible for obtaining this internally displaced person status, but still looking at the law itself, it's not that clear, because those statistics that we have seen is only those who registered, but actually there are more people who had to leave their homes who have not registered to date, but maybe they decide to do it now. And another thing is that this internal displaced person status can be also lost. One point is when the person resides permanently outside of Ukraine, but it's a bit of a long-term perspective. It would not happen if you go to another state for just a few months. However, the person has an obligation to inform the authorities about the change of residence within 10 days, and there is a presumption that if the person is absent from the registered address or where he or she currently lives, then the presumption is that the person returned to their previous residence. So it's unclear how that will also play out in practice, because a lot of people might have gone to a European states for just some particular time with the aim to return back. But the question if they will keep this internally displaced person status. So how that will be actually handled. And so there will be a need for some kind of coordination between the European states and Ukraine on the whole matter. But hopefully people would be able to return home. We know stories, and I know personal stories of people who left Ukraine like shortly after 21st of February that are actually already back in Ukraine, but they could flee again. So it's very unpredictable situation. I will just go back and stop sharing. But what I wanted to say, because there was a discussion on the right to work and the temporary status. I've been meeting Ukrainian refugees. At that point, I was in Germany because they just come with the trains, and what I kept hearing from them was that they were very afraid of not making an application for the usual refugee status. They were very particular that they want to have, I think in German law, it's paragraph 24, that they want to have this temporary protection because they want the right to work, and they need the work to keep supporting their families back in Ukraine, and also they plan to go back. So, we had another event here at the university today, where one panel was also on the refugee rights, where it was also highlighted the difference, and that might not be in the person's best interest to have this temporary protection status in the long run, right? But what I've seen personally, just my personal experience, that people are actually very afraid of the normal refugee status because work is very, very important for them. Yeah, there are a lot of challenges also within Ukraine with how to handle this humanitarian crisis and the war. But I sincerely hope that we will be able to secure the rights of those people who had to flee the war, and with the help of our neighbors and in Europe as a whole. So thank you.
Thank you. Thank you for your presentation and your final statement. And for highlighting this, bringing to the forefront the enormous relevance of internally displaced people that is often missed in public policy debates, and the numbers that you mentioned, how to actually also consider those who may not have registered, the many of them who may not have actually registered officially and still are in that situation, or some which may be, experiencing different experiences, different trajectories or aspirations, and they may be caught in between different statuses, be it internally displaced, be it temporary protection beneficiary, and so forth. And thank you also for coming back to the point of this morning, when some speakers said that indeed the short-term and the medium-term consequences for people to strategically choose not to apply formally for asylum and refugee status in light of the consequences on having access to specific rights, like the right to work. So thank you very much for that. Now let's move to our discussion lot. We have Catherine Goulard, she's Secretary General of ECRE, and someone who has been following and very actively engaging in EU public policy debates and the amazing work of ECRE, providing evidence to inform decisions at EU level, and your excellent role in policy. So Catherine, we are delighted to come with your participation.
Great, thank you so much. I was still scribbling down some notes and comments because there's such interesting presentations from the three panelists. So I have a set of comments. There are 6 of them, which are partly comments and partly questions to the panelists. I'm just going to go through them and then happy to hear from the panelists and their views on these different elements or their answers to those questions. From ECRO's perspective, of course, we're assessing temporary protection regimes from a protection perspective, of course, but I think there's also a practical dimension to this, and that's what we see with this contemporary example after the triggering of the TPD, but also with the historical examples. My first point is the decision, the political desire to put in place a temporary protection regime. I thought it was interesting that Jens referred to the limited appetite for temporary protection regimes in Europe between the late 90s and now. And I think this is interesting. It's also the reason we had to look elsewhere to see contemporary examples of temporary protection regimes, as during the panel just before lunch, for instance, that was part of that discussion. And I think particularly looking at the US and at Turkey as other examples. But my question is, why was there throughout that period such a limited appetite? And in retrospect, is this perhaps a mistake? I think it's certainly a source of reflection for civil society, because some of the concerns about the content of protection under temporary protection regimes, I would say, meant that there hasn't been the advocacy for the use of these tools that there should have been. Notwithstanding the valid concerns about content, but it's not necessarily the case that the content is weaker. And the second point, I liked Frank's comment that temporary protection regimes can have different agendas. And indeed, as we know, all legal instruments are tools ultimately to serve different political agendas. And there's no such thing as pure law that doesn't exist distinct and detached from politics. One element of the political agenda behind a temporary protection regime can be understood by examining the content of protection that is offered in a temporary protection regime. And with the current use of the Temporary Protection Directive, the TPD, of course, it was politically extremely important that this was activated. But I think the strength of the content of the rights attached is also extremely important. And that's not to say that those rights are at the level of convention rights. I'll come back to this afterwards because I think there's question marks there. But nonetheless, the strength of the content is good. I mean, if we look at the rights that those within the scope are to have, in theory, education, housing, social assistance, etc., right to work, crucial. And I think this takes us to the question that if the content is weak, of course, it's problematic from a protection perspective, but also it's problematic from a practical perspective, I would think, in the sense that the take-up is going to be is going to be lower. And particularly now when countries can't follow the example of Austria that was mentioned by Frank, of denying access to an asylum system for those who refuse to take up the temporary protection offer, essentially, or vice versa, to exclude temporary protection if they go through the asylum process. I think it was also interesting to hear Lilia's comments on the experience so far of Ukrainians arriving and in some cases preferring and indeed receiving legal advice that the temporary protection regime is the better option. I think this demonstrates to us the fact that rights have been stripped out of asylum systems, as well as difficulties attached to getting status. And so I think the question there is about does there always need to be one consistent system with high content of protection? And if not, are we in the kind of fragmented model with different lower forms of temporary protection in place? Does the pull factor argument that we usually dismiss, because in most cases there's no evidence that pull factors even exist, but I did wonder in a context like Ukraine, that had the scope of the TPD been wider, that this could actually happen. And without high content of protection, that may also come into play. So then the third point is a related one. What is the agenda? Hearing the discussion about the Balkans, so often it sounds as though the purpose was to avoid settlement. The purpose was that the durable solution for those people was return. But we know that the return rates were extremely low on the whole for those who fled from the wars in the Balkans. So actually that purpose doesn't seem to have worked. This time, it's almost the opposite. There are measures in place could facilitate integration. However, right now, the focus is very much on return. So I think that the question there is about, does it work if you design a lower standard protection regime with the idea that return is the objective? People integrate in different ways for different reasons. And actually, I would be interested, panelists, please correct me if I'm wrong, but I think we could say historically and relatively speaking, the return rates, when we look at former Yugoslav, Kosovo displacement from those conflicts are relatively low. And a related fourth point is in terms of integration. Now looking at the TPD regime in place. And I think for us, the link with integration is crucial. The success or otherwise of the TPD, certainly from a protection perspective, will now all be focused on the access in reality to the rights that are part of the regime. And that lies partly in getting the status registration. There are some issues, but they're frankly limited, they're minimal, and they're short term. The question is going to lie in things like interpretation of those different elements in the TPD. So what does adequate reception mean, for instance? And then of course, just the capacity of states to be able to provide people with those rights. And I would just throw the question out. I mean, for us, this seems something really quite interesting in terms of the sort of usual overstatement that the EU has nothing to do with integration because it's national competence. To what extent do you think that existing jurisprudence is going to be relevant here? We would say, particularly in terms of subsidiary protection, in terms of elements of the qualifications directive, there's a lot there that we could already start mobilizing to ensure proper interpretation of the content of the rights. As Jens said, in some cases this is quite vague, and that piece, we finally have perhaps an opportunity to implement the principle that integration should be from day one, which is often said but rarely happens, because the protection granting is immediate and people aren't stuck for years in asylum processes. And so and from our perspective, and I think the evidence comes out that actually if people have good prospects for integration, that doesn't necessarily mean that they're less likely to return. If we look at displacement from a number of regions over the last 10 to 15 years, it's actually people who go through initial period of being integrated quite rapidly who return because they have some capital, they have prospects, they have a way to manage their return. So interested in your comments on that. And then just a small question for Lilia. I think it's extremely interesting, your description there of the IDP regime, if we want to call it that. I would be interested in further thoughts on the interplay between the IDP regime within Ukraine and the temporary protection regime within the EU. And you mentioned the point of, for instance, I see it from an advocacy perspective, so I've already turned your comment into a recommendation, being that people should not lose the IDP status should they, for some period of time, be out of the country and covered by the TPD. Are there other suggestions you would make to ensure that there is a positive interplay between the situation in country and the situation in the EU in terms of legal status, interaction between the IDP regime and temporary protection regime? And I say that because unfortunately, it may be the most likely scenario that this is something that becomes a longer term conflict, but in parts of the country. So the IDP question remains a very crucial one. And my final point, the sixth and final point, is on lessons we might extract for legislative reform. And of course, the Pact, as well as the many other, the 2016 proposals, the instrumentalization package, where before this happened, before the invasion and the war, we had gone through a period of some 5-6 years of kind of being bombarded with legislative reform proposals to reform the Common European Asylum System. If we look at those proposals that remain on the table, many of them go in the exact opposite direction of this regime which has been put in place in response to the Ukraine crisis, being the triggering of the TPD, the strong content of protection, other issues. So I think my question is, does it still make sense to persist with some of these reforms? So some of you already mentioned this. What's different in this case? I mean, access at borders is being granted. It's not an issue largely, with some small exceptions. Protection is being granted as quickly as possible. Onward movement is not only not being prevented, it's actually being encouraged and facilitated. Family reunification is actually happening and again being encouraged, rather than being something that exists on paper as a right but doesn't really work very often in practice. If we look at the proposals on the table, and indeed the political debate that has led to them, it's something that goes in completely the opposite direction, limiting access, containing people at borders, putting in place measures that are likely to lead to denial of access, limiting access to protection, putting in place these incredibly complex, in our view, unworkable, but certainly practically challenging legal tools that are designed to limit the chances of getting protection, but actually create at the same time a huge burden on states. So how can we pull out some of this and feed it into that debate? Or are we in a situation where this these become too parallel, or continue to be two parallel tracks, the asylum system and the temporary protection regime? And you know, as a small note, I think the discussion on individualized assessment is interesting. I mean, of course, with the temporary protection regime, a specific category does not have to undergo an individualized assessment. In the debate on the asylum system, it's often completely the opposite, of course, that we find ourselves arguing constantly for the prime importance of individualized assessment, because group determination is used as a way to limit protection, as with safe third country tools and others. But the manifestly founded, the prima facie granting to a group hasn't, where it's in place, it doesn't work. I mean, where member states have track systems, they use manifestly unfounded, but they don't use the manifestly founded track. So my question is really to hear your thoughts on, are we overstating the case when we say, well, all of these reforms go completely in the opposite direction of what seems to be, in a sense, working, or at least has been decided as the way to respond to this crisis? And if that all continues, are there ways to try to bring in some of this experience or is a temporary protection regime more of a risk for others applying for asylum? Thank you. There you go.
Thank you, Catherine. Very excellent points. I would like to come back to the panelists who would like to react to some of the questions that Catherine has mentioned. There are a couple of questions also by our participants. I also invite those who are watching and listening, is your time also to post any questions in the Q&A option of Zoom. Please don't hesitate. Before that, perhaps our discussants, would you like to, any comments, any reactions to Catherine's questions? Jens?
Yeah, thanks. And also thanks indeed to Lilia and Catherine for your interesting presentations. I would like to respond right away to Catherine's question about individualized versus collective or group determination of status under ordinary examination procedures, which we often refer to as individualized procedures. I think it's important not to have sort of too much mystification about this individualization. It can be quite detrimental, in fact, and I think there's no logical conflict or dichotomy between having individual or individualized procedures on the one hand, and on the other hand, applying relevant and well-founded assumptions or presumptions of the need for protection. I mean, this is in one way the flip side of some criteria for accelerated procedures, which are based on a presumption of no need for protection, or presumptions of safe third countries and so on. And from my faraway background in administrative law, I would say there is no legal problem, I think, in operating presumptions. They, at the same time, they do get risky, of course, if they are not rebuttable in practice, which makes, for instance, them particularly risky in the context of accelerated and border procedures. But to go back to your question, Catherine, I would say that not least in a context where there has been a kind of group or collective determination of protection needs, it would make good sense, as far as I can see, in case the situation might become protracted, which we all hope it won't. It would then make good sense to operate certain sort of generalized criteria on the need for protection. I think the Danish authority, or I know the Danish authorities did exactly that when the temporary protection for Bosnians was ended, and they were allowed to have their asylum applications examined in the ordinary procedure. There were simply issued some guidelines for the immigration service in the way on the way in which it should approach cases depending on ethnicity, perhaps geographical origin, past experience of atrocity or persecution, and so on. Some of those general guidelines may actually have led to wrongful decisions in terms of allocating people to subsidiary protection who ought to have been recognized as convention refugees. That may be a risk, but I don't think it is necessarily linked to the very idea of having a kind of prima facie approach to that. Prima facie approach is even recognized in the UNHCR handbook, so why not use it if it is an appropriate administrative tool? I think it is possible to apply such an approach without risking negative decisions. And as you said, Catherine, it's of course also it's always in the context of negative decisions we are afraid of or skeptical towards group determinations, because they may then end up in de facto collective expulsions. Sergio, should I also answer the question that was addressed to me in the Q&A?
Yes, let's take that chance and go for it. So
Great.
One of the participants, I guess you read the question, relates to the idea of secondary movements for those colleagues who are—
Yeah, exactly. Talhagunai's question. I'm afraid this is not a question which is really within my expertise, although I did allude to some of this perhaps in my presentation. I would say the question is, do I foresee an upcoming paradigm shift? And that's of course hard to say, but I'm rarely so optimistic that I can believe in that. We have seen also today, we have heard explanations of the remarkably more positive approach to asylum seekers or protection seekers or displaced persons coming from Ukraine, that what we are used to. And that is not only the case in the V4 countries. I would say we have seen similar debates, perhaps not as extreme, but we have clear similar tendencies in Denmark and other countries. And I'm afraid that once we get back to normal, if we can use that term, then I think asylum seekers will be seen as largely unwanted, and therefore there will be again this perception that they should be controlled and contained more or less. So I'm afraid that the secondary movement syndrome will survive this situation. Perhaps the question is actually, as I indicated already, when the free intra-EU movement of Ukrainians will be seen as a problem. That already there, I wouldn't be surprised if we will see problems and containment attempts. Thank you.
Yes, thank you so much. Next, I think Frank, you raised your hand first, please.
Okay, I want to answer a few questions of Catherine. This little political appetite for temporary protection regimes is indeed a lasting element, which we see when Germany changed its law in 1993. It had a scheme of temporary protection. At that time, the German recognition policy was very strict. They had this state-oriented restrictions, so you should only be persecuted by the state. So for civil war refugees, there was no German recognition, and they argued in parliament too that in the whole discussion for the change of this law that they would have a special status for civil war refugees. So it was all in place there, and then the Yugoslavians came and they didn't use it at all. It started in 92, the end of 1991, 92, but also in 1993 they could have used it. And there was a whole discussion between the Länder, the regions, and the federal government on who is going to pay for the civil war, for the temporary protection of civil war refugees. But they never found a solution. There was no political will, which is very interesting to see that there was so little political will to implement that. It had been agreed between the different parties for the compromise on the changing of the constitution, but still only in 1999, the Kosovo crisis, then it was being implemented. In Austria, it was also in the 91 legislation, has not been used. So it was a dormant regime also on the national scene. So I think the main argument is that it's very difficult to master temporary protection. Once you start it, you give, in fact, to a certain extent, a blanco check. A second remark of Catherine was that the stressing of the return, which was in the 1990s, the early 1990s, the main focus, that people should return. Catherine said that the return rates from the Balkan wars was very low. I don't think that, but we, in our research, we looked mostly on the on what happened in 1991, 92, in the terms of immigration policy, in terms of protection provided. But from the literature, I've found that, like in Switzerland, but also in Germany, a large number of people returned. They had to return. They did it way too early. Already immediately after the Dayton Agreement, the Germans started, especially in Bavaria, started to pressurize people, harass people because they had to go back. But then it was not safe yet to go back at that time. So they did it way too early, but still many people returned. They got also financial support. There were reconstruction grants for people who returned. So I'm not so sure if the return rate was that low. Yeah, then there was a question among the question and answers. There was the question: is it different now because civil society is much more mobilized in an unprecedented manner? I'm not so sure if in the early 90s that was not the case either. Also then there was a large effort to assist the Yugoslavian refugees. So, but of course the geopolitical context is very, very different. Today there was in the newspaper, in the Belgian, in Flemish newspaper, and which it has to be alluded to by a person from the Commission. There was a survey, 3,000 people have been interviewed about their attitude towards Ukrainian refugees, and there is still a very open attitude towards it. 25% of the people want to take somebody in their house even. So that is probably different. But I wouldn't say that this mobilization of civil society was not there in the early 1990s. And of course, with this Article 11 not being applied, makes that coordination will be much more important. As Jens mentioned too, people can move around. Even at the time of the Kosovo crisis, when the Germans lifted the protection for the Kosovo refugees, it didn't mean that they all returned. A lot, for example, Belgium had 15,000 Kosovo refugees who came, most of them came to Belgium after the Germans lifted their protection scheme, and they came to Belgium and asked for asylum then. We never, even in 2015 in Belgium, we didn't have such a high asylum number of asylum seekers than in 1999 due to the Kosovo crisis. Then there was no coordination. Now there will be, without any doubt, much more coordination, and that's probably much better too. Okay, thank you for the attention.
Thank you, Ilya.
Yes, thank you very much, Catherine, for your comments and questions, and to everybody for the discussion. When I'm thinking about the internally displaced person status, EDP, and how it can be in some positive interplay with the temporary protection status, yeah, I think definitely there is a need to somehow coordinate it on some level, because people, I know a lot of uncertainty now. Those who are internally displaced in Ukraine, yeah, they have been, it has been in media that they contact the lawyers. What can I go to the other country without losing the status? Because nobody's planning to move from Ukraine for a long time. So basically, everybody just hopes I can go back home, and it's just yet another uncertainty, because of course this temporary protection status, it's a collective one, but it still takes time once you apply to actually get your documents in order and to actually have access to the work market. It's not like that you come and just apply and then you suddenly can work anywhere. So so those people are faced with a lot of uncertainty. Yeah, how to solve that? I will not be the right person, but I hope that yeah, that this issue is worked on. It is also important for us in Ukraine to know how many people are basically, how many people left, how many people are in need of support, like why those who had to flee, why they have not yet registered for their status. Maybe they plan to go abroad for some time and they thought, okay, they would lose the status anyway. So yeah, it's a lot of questions. So that is definitely something to clarify. And then you also mentioned this integration rate, that those people who were able to integrate into the society like quicker, then they were actually returning back to the state, like on was like higher percentage of people who returned back. And then I never thought about it, or like I'm not I do not have knowledge on that statistics, but I thought from like Ukrainian perspective, we of course hope that war ends as soon as possible, and it is important for us that our people are coming back, but not that they just lost, I don't know, 3 years of their lives, but actually that they had work experience, that they that they also get to continue whatever is their profession or continue their education, right? That they build a network, because we will need it then to get our state basically back on track. So that is very important. It's not only of taking care of those people because they lost their house, of course, and everything, but it's also about enabling them to basically continue living a normal life once it is over, like in Ukraine or elsewhere. Yeah, thank you.
Thank you. I mean, on this point, perhaps we can come back to Catherine's comment on, on integration. So, and the scope of the right to work, because this is something that, it's been mentioned before in previous presentations. The right to work in the scope of the Temporary Protection Directive and the right to work in the scope of refugee law and human rights law, without forgetting the International Covenant on Social, Economic, and Cultural Rights, and the way in which human rights law often provides even wider connotations and scoping of the right. So if anyone would like to comment on that, and also on the extent to which this integration concept works out differently, because we also heard this morning that the huge discrimination between how Syrian national would experience the whole asylum procedure and having access to reception conditions, which usually are designed to, socioeconomic inclusion, from people fleeing Ukraine who do not need to have all those pass by through all those steps, and where registration seems to be a key issue. But after that, it's not a question of having access to reception conditions. So if someone could comment on that. Perhaps, Jens, do you have any comment on integration? The point of Catherine on integration and existing jurisprudence relevant here? What about the pact? Catherine, you would like to follow up on this?
I'm happy to just come back in briefly and perhaps answer the question that's directed at me in the chat. I mean, I think on the integration question, I didn't hear that session this morning. I just heard the one just before lunch, but I think the real contrast is, again, with asylum applicants, of course, and the fact that in many member states, people don't have the right to work. And then in other cases where they do have the right to work, the reception piece undermines that, be it through a mandatory dispersal system or through restrictive measures that people face. So for us, I think some of this is about understanding, and are there political arguments that can be made to show that it's also to the advantage of the states that they make it easier for people to be included through access to their rights. And we know, and I'm sure you discussed that this morning as well, that there are reasons, good and bad reasons, why things are different this time round, and that asylum and migration policy is characterized by racial and religious bias. And so what applies in this case might not be generalized or to apply elsewhere. But we hope that we can bring out show some of the value of why the principle of integration from day one exists, because so that people aren't stuck in that limbo for the variety of reasons that happens. In terms of the question, implications of this solidarity on the solidarity mechanism in the pact, I think at the first level, no, there won't be a positive influence, because the solidarity mechanism in the pact exists within a wider model for the asylum system, where the solidarity mechanism is there as compensation for the increased containment and responsibility of people at borders, and increased responsibility of countries at the EU's external border. So it's hard to really compare solidarity because it's playing a different role. From our perspective, we would suggest that it is again the time to question whether that model and what is the model that the pact represents, whether this is right. I mean, clearly in terms of fundamental rights and protection, there are serious problems, but also in terms of practicality, in terms of making asylum systems function, we would also see challenges. So I think the solidarity mechanism, there isn't an immediate and direct impact. Again, though, it's about trying to pull out some lessons from this experience and applying them more widely. So, for instance, the model that's in the pact is based on, one part of it is based on the fear of secondary movement that certain countries have. And here we may be seeing that onward movement is not necessarily a negative thing, and that there may be benefits to states as well. So if people have the chance at onward movement, they end up with family, there's family reunification, and then their prospects of inclusion in societies, contributing, finding work are enhanced. So those are possible positive scenarios. Of course, that there are many, many ways this can play out. But I think it's a question of seeing whether a different approach, the use of different tools, can be generalized.
Thank you, Catherine. Any final remark by our panelists? There are a number of questions that have been posed, but time is also passing. So if you could select, or Jens.
Thank you. I just noted Boldish's scarily interesting question. It is in the chat, I think. It is describing a situation of a frozen conflict where the Russians, one way or the other, managed to occupy or secede parts of Ukraine. And you ask then about the cessation of temporary protection. I think in general, that might, of course, make the need for continued temporary protection at least change in nature, because then it would not be an armed conflict, but there might be other things which might then make the displaced persons fit more readily into well-defined protection categories, so to say, because then we'll need a whole set of differentiations or distinctions between, geographical origin and political, ethnic background, and sexual orientation, gender identity could also be a factor there, depending on who will then be in effective control in the Ukrainian parts, and also, of course, also in the other parts of the country. It should be impossible, I think, to assume that EU member states would then expect Ukrainians to return to the Russian dominated parts of Ukraine. But you then finally raise the question of internal protection alternative. Yes, that would indeed be a likely outcome, I think, under certain assumptions, of course. Many countries already, I think, have quite a predisposition for enhanced usage of internal flight or protection alternatives, even in connection with cessation. So I think that there would definitely be a kind of preparedness to try this out once the TPD becomes deactivated. And this maybe also touches upon another question raised in the Q&A function by what I think it was it was Anna who talked about the strong involvement or mobilization of civil society. I think that is part of the explanation why the implementation of temporary protection is different. I mean, the difference is, of course, that it was activated in the first place. But on the other hand, I think that it is rather a kind of two separate developments with a common a common causation, so to say, which was the political approach to accommodating the protection needs of Ukrainians right after the invasion on the 24th of February. We already heard from Boldisha and others about the strong or high importance and strong involvement of civil society, which reflects, of course, sympathy and engagement in the population. And that, I think, was in a different setting, was also what motivated politicians at EU level to activate the TPD. Then that again has also to be seen in connection with the fact that Ukrainians were already a privileged group of third country nationals because they had free entrance already due to the visa exemption. So I think the role of civil society is important, but it doesn't directly explain, I think, the activation or the actual implementation of the TPD. But it may then get a role in case of a long duration with temporary protection, because then it may impact the tendency to or incentive towards a secondary movement for those under temporary protection. I'm afraid this was not a clear answer to that, but at least it was an interesting question, and I hope to share some reflections on that. Thank you.
Thank you. Thank you to all of you, all the speakers, and to Catherine as well, and to all the colleagues who have posed questions and raised also comments. We need to close this panel and move towards the concluding remarks. We have a short time allocated for each of us. Perhaps we can start with Hakan.
Okay, thank you, Sergio. When I listened to the presentations today, I had a need to distinguish between two aspects. Things that are common to all flight situations. We see them also here, like, for example, correct implementation of international law, EU directives and national laws, correct understanding of the notion of protection. There is variation in all these things from country to country. And then nationality, ethnicity, race, gender, and status-based discriminations in protection, we have them here, like in other refugee situations. Increased opportunities for traffickers and other exploiters, we will have them here as well. And challenges in relation to integration and public opinion problems, we will soon have these too in our European countries as more as poorer sections of the Ukrainian refugees start arriving, who need more welfare services than now. We will start having these problems too. I have seen examples of these in Norway, people talking about that. They should be satisfied with the fact that they are allowed to save their lives by being on our territory. They shouldn't ask for more rights. And there's already a lot of research available on these issues, and I think the findings there would apply also to what we have in this situation with people fleeing the Ukrainian war. And aspects that are specific to people fleeing the Ukrainian war is more interesting to talk more about. For example, I think Lilia's presentation was one of the most important ones here, because she introduced the factor of internal displacement and that it is being used in Ukraine, and the interactions between the international law and international internally displaced people in Ukraine. This is an important thing, because we don't see this actually in other conflicts in Africa. Forget about internal protection in Africa, forget about this in Mexico, but we can have this here actually. And another thing that's specific here is that Ukraine, all of its neighbors are rich people. So regional solutions to the refugee situation here is more probable than it is in Africa, Latin America, and poorer regions of the world. So in that sense, we have a bit more special situation here. But as I said, the most important problem here is that the politics of protection comes as an obstacle. The tensions between the different political groups within the countries and at the European level and at the global level as well allow different groups to come into a contestation and conflict with each other about the definition of protection, about the personal scopes who would be admissible as refugees, who deserves protection, and these are all normative concerns. So the political dimension should be explored more in this situation, and concerning the development of the Common European Asylum System, this started in 1990s and it's still developing. It's developing based on experiences of different conflicts that Frank so eloquently described, and Jens also gave many important details about these things. What would the contribution of this situation be in this context? It is still very much unclear to me. What would this conflict imply for the development of the Common European Asylum System? It's an important question that we should explore more. Thank you.
Hakan, Luke?
Yes, thank you very much. Thank you, Hakan, for already pinpointing the main points of discussion. What I'll do is maybe I will be a bit more arbitrary, because I will just highlight 3 points that kept coming back in the 3 panels, and I will, in a very egoistic way, take some conclusion based on that for a future direction that our project, so the VNER project, could take, knowing, of course, that we can have a dialogue about this with the other project, and I think that will be of a great added value. So the first point that kept coming back in all 3 panels is the added value of a common EU response. I think that was mentioned quite a lot by the participants, that this was a relief, considering, for example, what happened in the 90s, or what is happening in other world regions, such as South America, where there wasn't such a common EU response to the mass displacement of Venezuelan refugee. This common EU response, it has also been highlighted as being positive because it was done in a spirit of EU solidarity, meaning by that there was no prohibition of onward movement to other EU countries. And I think that one of the lessons from the discussion we had today is also that the fear of onward movement shouldn't be overestimated in the context of temporary protection, as in other world region, people tend to stay close to the conflict itself. That's what's happening, for example, in Uganda right now, when people are forced to flee the DRC. They stay close because they have the hope of going back probably quite soon. And that's also what seems to be happening right now in Poland and the other neighboring countries. Which leads, of course, to another question, which is how can we also, as EU member states, support these countries? Now, what can we do with that, with the VNER project, at least? Well, of course, these are very political questions, and we're scientists, so we can only bring data and scientific analysis. But I think that one thing we can do is to help going forward this common EU response across the board by favoring practices that are much more common than what we're seeing right now. And we can do that, for example, based on concepts such as vulnerability that are adopted at EU level, that are guiding policy concepts at EU level. It's not the only one, of course, but it's among these guiding policy.
There are some technical difficulties. It may be related to the headphones. Perhaps if you have a possibility to disconnect the headphones.
Can you hear me now?
Yes, perfect.
Yes. Yeah, it's very strange when when it's disconnected, I'm muted, but when it's connected, I'm muted. Anyway, I was talking about how getting to a better understanding of this legal concept by working on how and by providing knowledge and additional knowledge on how these legal concepts are being implemented on the ground and are being understood on the ground. The second point I wanted to raise is this relationship with the asylum system, and it has been raised also in a consistent way throughout the panel. It has been said by the speakers that the choice to have this temporary protection mechanism was made with the view not to overburden the asylum system, not to overburden the reception system. This, of course, has some positive effect, such as the fact that the Ukrainian temporary protection beneficiaries can have access to the labor market, which facilitates their integration, but it also raises additional issues and risks such as exploitation, risks such as the fact that there is no adequate state response because they're outside of the asylum system. Now, what can we do with respect to this in terms of producing knowledge as part of the VUNA project? Well, we can think on how to avoid these negative side effects by having an approach that is sensitive to the vulnerabilities, to the specific needs that some people face. And I think we had some discussions on that with Letizia Palumbo's presentation, and it was emphasizing, among others, the need to have some support measures that guarantee equal access to the labor market, for example, so that the situation of vulnerability in which people may be submitted to exploitation doesn't arise. Finally, the last point, that was also a transversal point throughout the tri-panel, is the issue of temporality. So if we take a human rights-based approach, if we take the perspective of the temporary protection beneficiaries themselves, it's also important to realize that by definition, this scheme, this kind of policy answer, puts them in a situation in which they have to manage a certain limbo. They are in a temporary situation, which makes it sometimes a bit difficult to make further choices and to move forward. And I will finish with that simply by emphasizing that in the current research phase of the VUNA research project, that's one of our main findings, that when it comes to experiences of vulnerabilities, these are not so much linked with gender and other personal characteristics. These are much more linked to situations of legal limbo, of uncertainties, in which people find themselves unable to develop resistance strategies and resilience strategy because they're in a context which is not supposed to last, and in which they have no perspective of knowing if it will last and if it's worth activating various resources and identifying these resources to overcome the difficulties they are facing. And that will be my final word. So this temporary protection was, of course, a necessary move, but it also puts people in a difficult situation from a human rights-based perspective. And one day it might be, if the conflicts end up in a kind of protracted situation, that other solutions will have to be found. But thank you very much again to all the speakers for the very interesting and rich discussion, to which I'm making absolutely no justice by making this very short summary. Thank you.
Thank you. Thank you so much, Luc. And just to also close today's webinar, I mean, many of the elements we've been talking about were kind of raising the question regarding, the extent to which we are witnessing change or continuity, the question of novelty or continuity. And many of the colleagues have raised persisting and latent identity politics and rather xenophobic and discriminatory framings of certain instruments and policy approaches, including some excluding others, based on a number of grounds, which need very detailed justification by state authorities to provide grounds for their legitimacy, and of course, when affecting specific communities and people based on their race, ethnicity, religion, raising a whole series of problems, as we've seen and discussed today. But also very interesting, some colleagues also mentioned this foreign affairs and geopolitical dimension behind some of the temporary protection experiences and policies that we are witnessing around the world, and the way in which they intersect with the national or domestic politics. And this made me think, what about the individual? What about the human dignity of every individual? And leaving so much discretion then to executive governments to change their minds from one day to another. And yes, there is no perfect system, there's no perfect policy, and and it is very difficult to find the ideal policy around the world when it comes to questions of asylum and protection. And yet today we've heard some stories showing some inclusionary or protection-driven examples where we can and actually are drawing, learning from these experiences. And it is very interesting how do they intersect often with exclusionary components. Those very policies, we've heard experiences in South America, we've heard experiences in other regions, in South Africa, we've heard in Jordan and so forth, and how they actually combine both. They present some interesting protection-driven components, but also they, paradoxically come along also some exclusionary ones. Group-based prima facie protection, yes, very, inclusionary in the sense of putting people, not requiring people to pass through lengthy asylum determination procedures and so forth, and recognizing a number of socioeconomic rights to those people, and yet many of them being constrained to only certain communities or nationalities, so raising questions of discrimination, also posing dilemmas from the perspective of registration. We've heard today a lot of obstacles in access to registration as barrier, questions of privacy. I think this also was part of the conversation today, how important it is to, especially nowadays, to that technology and databases for registering people are so fashionable, and yet also based on historical knowledge, they can be used in very problematic ways for purposes distinct to the objectives they may be set up for. So questions of the use of biometric data, and ownership of data have been pointed out. And if anything, many of the colleagues raised the problems to have effective access to decent work. So while many different experiences around the world, we've seen schemes allowing access to the labor market, it's still very difficult to ensure decent work and fair work of those who are subject to this. Now, something I learned today as well is the untapped potential of regularizations. Regularizations being in many European Political debates, kind of like a forbidden thing, and yet many countries in Europe and elsewhere, as we've learned today, this is a practice, it's a common practice, often public or non-public, publicized, and yet it does offer very realistic and practical outcomes to prevent irregularity, to address questions of mental health. We learned that today as well. Anxiety and stress by applicants who are kept in this temporariness, time-imposed regimes, which do not think beyond, temporary stages. And the last point is something that also is calling for very much, I think, is to have a detailed examination of the implementation of the Temporary Protection Directive by all member states. It was quite worrying to hear how some countries are tightening up conditions of accessibility. So really to look carefully at who has access to what, a detailed assessment on the dynamics and member states' compliance and how actually this intersects with their obligations under EU law. So a number of elements that, bring and highlight quite concrete and specific findings and recommendations we've heard today. And just to also close the webinar, on behalf also of the colleagues, I think this has been a great opportunity to join forces with Vulner and Protect project, and we very much enjoyed this collaboration, and we hope to have other occasions in the near future as our projects also evolve and reach the final research findings in the time to come. And a very big thanks to everybody who has been involved in all the teams of Protect, Vulner and Asylum in the organization of this event and the communications and dissemination of the webinar, and to all the colleagues who have, of course, been speakers and discussing. And to all of you who are still listening and watching this conversation, very big thanks to all of you, and a wonderful afternoon and evening.